Now, as a continuation for the Family Code of the Philippines, to reiterate, in proving psychological incapacity, there is no distinction between an alien spouse and a Filipino spouse to that of Filipino spouses. Okay? So, even if an alien spouse, you can file a annulment. A Filipino spouse can file an annulment here in the Philippines. Okay? Because divorce is not accepted practice in the Philippine setting. Okay? So, Supreme Court declared in the case of Chiming Choi versus CA, love is useless unless it is shared with another. Okay? So, no award of moral damages in psychological incapacity. Then, legal separation. Marriage is valid and the ground for legal separation occurs only after the celebration of marriage. Okay? Marital bond is not broken. So, legal separation, there is no severance. Okay? So, marriage is still subsisting. Okay? There is only a separation of bed and board in legal separation. Now, let's go to Article 37 or incestuous marriage. So, even if solemnized abroad in accordance with the laws in force in the country where they are solemnized and valid there as such incestuous marriage is not recognized as valid in the Philippines, okay, by reason of public policy. So, even though it is accepted practice abroad, here in the Philippines, it is void. Okay? Next is Article 38 of the Family Code. Void by reason of public policy. So, the intention of the law is to prohibit marriage between persons who were once related to each other by affinity as parents-in-law and children-in-law, even if marriage, which serves as the source of relationship of affinity, is already dissolved or terminated by reason of death or final judgment of annulment or of absolute nullity. The adopted child is prohibited from marrying only the legitimate child of the adopting parent. Okay? So, prohibition does not extend to adopters' illegitimate children. So, these are just matter of reading. Okay? The notes are already uploaded in the files. Okay, for reference, check it out. So, another issue is intentional killing of spouse. So, a prior criminal conviction is not necessary to render the marriage void. Okay? The killing, whether perpetrated by the spouse or by another person, must be animated primarily by the intention or desire to do away with the victim, who is an obstacle to a contemplated marriage for the purpose of marrying the surviving spouse. So long as killing is for the purpose of contracting a marriage with the surviving spouse, the marriage should be void ab initio or void from the very beginning, even if the surviving spouse was not aware of such plan. Okay? So, void. For example, you want to remarry, so you kill your present wife. So, the subsequent marriage is void, even if the female is not aware of such plan. Okay? Next is Article 39. An action or defense based on the absolute nullity of marriage is imprescriptible. Okay? So, it does not prescribe. You can assail it within your lifetime or even after your death. You can, your relatives, your children can assail it. So, void marriages can be questioned even after the death of either party. Okay? So, another administrative order from the Supreme Court provides that a petition for declaration of absolute nullity of a void marriage will be filed solely by the husband or wife. And if filed, the case shall be closed and terminated upon the death of either parties at any stage of the proceeding prior to the entry of judgment. It now appears that a direct proceeding for the purpose of obtaining a judicial declaration of nullity of a void marriage may no longer be filed after the death of either party to such marriage. Okay? So, it may still be subject to collateral attack. So, that's the meaning of collateral attack. So, by collateral attack, it means that it can be assailed by third parties, relatives, children who are affected by that void marriage. Next is Article 40 of the Family Code, which provides that there is need for judicial declaration of nullity of a void marriage. Okay? So, even if the marriage is void from the very beginning or it has no legal effect, but still, for formality purposes, a judicial declaration of nullity is necessary. Because how can you remove it in your records if there is no judicial determination? Okay? So that is why you still need to apply in court that your marriage should be declared void from the very beginning. So the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such previous marriage void. Okay? Just like what I said earlier. In order to erase in your record, you need to file it in court because only court orders will be given weight, especially when it affects your civil personality. Okay? However, other than for purposes of remarriage, no judicial action is necessary to declare a marriage an absolute nullity. Okay? For example, for purposes of determination of heirship, settlement of estate, and etc., the court may pass upon the validity of the marriage even in a suit not directly instituted to question the same so long as it is essential to the determination of the case. Subsequent marriage without judicial declaration of nullity of previous marriage is void ab initio. Okay? So, bear in mind, the subsequent marriage, if you will not perform the formality required, then even if your previous marriage is void, your subsequent marriage will also be void if the formalities mandated by law is not complied with. So, the intention of the Family Code is to declare a marriage void ab initio by reason of non-compliance with the provisions of Article 40. A subsequent marriage entered into in violation of Article 40 is a void marriage under Article 35, Paragraph 4. So, the applicable property regime is that provided of Article 148. Okay? So, please refer to the Family Code class which I have uploaded in your files for reference. Once again, I would like to reiterate that my discussion, this presentation is but an overview of the Family Code because the Family Code class is very broad, okay? It needs many days or even months to discuss its provisions, okay? However, in our case, we are only given 4 hours. So, we will just make a rundown, okay? That's why I am using this reviewer by Who's the owner of this reviewer? This reviewer is not mine, class. I'm just using it for discussion purposes. Miss Abissamis. Okay? So, to continue, so let's go to property relations. So, in a void marriage, regardless of cause thereof, the property relation shall be governed by the provision of Article 147 or 148, as the case may be. Okay? So, when you say void marriage, class, the marriage is void from the very beginning. So, its property relation is governed by co-ownership. Okay? Still 50-50. So, even if the wife is a housewife, if you have acquired a lot together, then that lot will be divided 50-50. Because the housewife, its house activity is considered the contribution. Okay? So, in bigamous marriage, which is void under Article 35, the property regime is governed by Article 148 or co-ownership. Article 147 governs the property regime of void marriages. Okay? So, once again, you need to prove this in court, class, whether or not what property regime would apply. Okay? Now, let's go to filiation. Children conceived or born before the judgment of absolute nullity of marriage under Article 53 are considered legitimate. On the other hand, children born or conceived of void marriages under Article 35, Paragraph 4, and Article 40 in relation to Article 50 are illegitimates. Okay? So, for reference, check out your family code. Look at the articles. Like what I said earlier, this is just an overview of the topic. Okay? So, Article 40 is applicable to remarriages entered into after the effectivity of the Family Code on August 3, 1988, regardless of the date of the first marriage. Okay? So, once again, as declared by the Supreme Court of the Philippines in the case of Mercado versus Tan, a judicial declaration of nullity of a previous marriage is necessary before a subsequent one can be legally contracted. One who enters into a subsequent marriage without first obtaining such judicial declaration is guilty of bigamy. Okay? So, the principle applies even if the earlier union is characterized by statutes as void. Okay? So, do not forget the formal requirement of nullity of marriage, class, before you remarry. So, without a judicial declaration of its nullity, the first marriage is presumed to be subsisting. Okay? Now, let's go to Article 41 and Article 42. So, general rule, any marriage contracted by any person during the subsistence of a previous marriage be null and void and may be found guilty of bigamy. Okay? So, even though the previous marriage is void, class, you still need to have a judicial declaration before you can have a subsequent marriage. Okay? However, it accepts of exception. Okay, what are the exceptions? So, first, prior spouse of the contracting party must have been absent for 4 consecutive years or 2 years where there is danger of death. So, the other party can remarry if this situation happens. Okay? There is certainty of death. Okay, spouse present has a well-founded belief that the absent spouse is already dead. a judicial declaration of presumptive death of the absentee, for which purpose the spouse present can institute a summary proceeding in court. And then there must be a judicial declaration of presumptive death. Otherwise, the subsequent marriage is void ab initio. Okay? So, requisites for declaration of presumptive death. So, in the case of Republic of the Philippines versus Nolasco, Supreme Court declared that absent spouse has been missing for 4 consecutive years or 2 consecutive years if disappearance occurred where there is danger of death. Present spouse wishes to remarry. Present spouse has a well-founded belief that the absentee spouse is dead. And then present spouse files a summary proceeding for declaration of presumptive death of absentee. So, these 4 requirements, class, should be complied before the other party can remarry. Okay? So, these are the requirements of the law. There must be a declaration of presumptive death of the absentee spouse. So, effects of judicial declaration of presumptive death. So, absentee shall be presumed dead but only for the purpose of allowing the present spouse to contract a subsequent marriage. Okay? So, present spouse will then be capacitated to contract a subsequent marriage. It is without prejudice to the effect of its reappearance. For example, the absentee spouse was, for all intent and purposes, declared dead, okay, by virtue of the requirements of the law. However, the spouse reappeared. Okay, so what's the effect? So once reappearance is established, the presumption of death is rendered ineffective. Okay? So, family code is not clear on the effects of the declaration upon the property regime of the previous marriage. Okay? So, effects of recording of affidavit of reappearance. So, the mere reappearance of the absentee spouse does not terminate the subsequent marriage. Okay? So, it is the recording of the affidavit of reappearance of the absentee spouse which results in the automatic termination of the subsequent marriage. Since the termination of the subsequent marriage is automatic and without need of judicial intervention, the second spouse, barring the existence of other impediments, may immediately contract another marriage. Since the requirement in Article 52 do not apply in case of extrajudicial termination of subsequent marriage under Article 41. Okay? So, the reappearance of the absentee spouse will automatically terminate the subsequent marriage. Okay? However, the spouse who subsequently married, okay, the other party, he can or she can remarry even though there is no judicial determination of such status. Okay, because the reappearance, when he filed an affidavit of reappearance, the effect is automatic. So the affidavit or reappearance may be executed and filed by any interested person and not only by the reappearing spouse. Article 43 and Article 44 of the Family Code, which provides that the custody and support of the children may be the subject of an agreement between the spouses to the subsequent marriage. In case of dispute, the matter shall be decided by the court in a proper proceedings. Okay? So, upon termination of subsequent marriage, the capital gains and the absolute community shall be dissolved and liquidated. So, these are the property regimes. Okay? So, donation, propter nuptias. Okay? So, donations by reason of marriage are those which are made before its celebration, in consideration of the same and in favor of one or both of the future spouses. As a rule, it shall remain valid. Okay? So, if the donee contracted a marriage in bad faith, such donations are revoked by operation of law. So, when you say bad faith, he has previous knowledge of the absence of the other spouse. Okay? But still, that spouse continued to marry the other spouse despite the knowledge. Okay. So if both spouses are in bad faith, in which case the subsequent marriage is void, all donation by reason of marriage are likewise revoked by operation of law. Okay? These are just matters of reading, class. Please refer to the notes that I have uploaded. And then Article 45 and Article 47. A marriage that is annulled presupposes that it subsists but later ceases to have legal effects when it is terminated through a court action. So what are the characteristics of voidable marriage? So when you say voidable, it enjoys the presumption of validity until proven otherwise, okay, declared by court to be void. So valid until otherwise declared by the court to be invalid, of course. Defect must exist at the time of the celebration of marriage. Cannot be assailed collaterally except in a direct proceeding. Can be assailed only during the lifetime of the parties and not after the death of either. Only parties to a voidable marriage can assail it. Action for annulment is subject to prescription. And then defect is generally subject to ratification except for grounds mentioned in Article 45, paragraph 5 and 6. Okay? So the law deems to be insufficient the consent given by a party who is at least 18 years old but below 21. Consent is defective. Okay? So just a matter of reading, class. By the way, this reviewer also I have uploaded in your notes. Fraud as a ground for annulment of marriage refers to the non-disclosure or concealment of some facts deemed material to the marital relations. Okay? So the word concealment, class, could be a reason in order to invalidate marriage. For example, if the other party is afflicted with STD at the time of the marriage by itself and even without concealment, is a ground for annulment so long as the disease is serious and appears to be incurable. Okay? So what is the doctrine of cranial cohabitation? If the wife remains a virgin after 3 years of cohabitation, the husband will be presumed impotent and the burden to overcome such presumption will be shifted upon him. Okay? So, if you've been married for 3 years and still your wife is a virgin, then your marriage can be invalidated through court proceedings. So, what are the requirements? Incapacity must be existing at the time of the celebration of marriage and then continues up to the filing of the action for annulment and then appears to be incurable and must be unknown to the other contracting party. Okay? So, just a matter of reading, class. Okay, the effect of final judgment, of course, it will It will dissolve the special contract of marriage as if it had never been entered into. But the effects of marriages are not totally wiped out. Okay? Just a matter of reading. Article 48 and 49. Matter of reading. Article 50 and Article 51. Marriage that is void ab initio is considered as having never to have taken place. So, judicial declaration of nullity retroacts to the date of celebration of the marriage, and insofar as the vinculum between spouses is concerned. So, all children conceived and born outside a valid marriage are called illegitimate unless the law itself gives them legitimate status. Okay?